Welcome back to Customs GST Advisory channel of customsgst.com. In last video, we had discussed about the jurisdictional facts and adjudicatory facts in the context of Section 74 of the CGST Act. The link of last video is given in the description of this video. Now, we will examine in detail the concept of jurisdictional facts as given by the Supreme Court in various judgment. Sit back and relax and watch complete video for clear understanding of the topic. Imagine a building. Before constructing the walls, before adding the roof, before painting the interiors, the foundation must exist. Without the foundation, the entire building collapses. The law works exactly the same way. Before any officer can issue a show cause notice, before demanding GST, before confiscating imported goods, before alleging fraud, before invoking the extended period of limitation, there must first exist the foundation of jurisdiction. That foundation is called jurisdictional facts. If those facts do not exist, the authority possesses no legal power, and every subsequent action becomes vulnerable to judicial review. Today, we shall understand the constitutional foundation of jurisdiction through three landmark Supreme Court judgments, and then apply those principles to customs, GST, and other indirect tax laws. Every legal authority derives power from a statute. An officer cannot exercise power merely because he believes he should. He can exercise power only if Parliament has authorized him. Jurisdiction, therefore, means the legal authority to decide, to investigate, to assess, to confiscate, or to recover tax. Jurisdiction is never presumed. It must arise from law. The statute specifies who may act, when, against whom, under what conditions. Those conditions constitute jurisdiction. Every statutory power has certain conditions that must exist before that power can be exercised. These foundational conditions are called jurisdictional facts. They are not evidence, they are not findings. They are not conclusions. They are the facts whose existence gives birth to legal authority. Without them, jurisdiction never comes into existence. The authority cannot create jurisdiction merely by alleging those facts. The facts themselves must objectively exist. In Raza Textiles Ltd versus ITO, the Honorable Supreme Court laid down one of the most fundamental principles of administrative law. The Supreme Court held that an authority cannot confer jurisdiction upon itself by wrongly deciding a jurisdictional fact. In other words, the officer cannot simply declare, "I have jurisdiction." The court will independently examine whether the foundational facts actually existed. This principle completely changed administrative law in India. In Arun, Kumar versus Union of India, 2007, the Supreme Court further refined the doctrine. It distinguished jurisdictional facts from adjudicatory facts. Jurisdictional facts determine whether power exists. Adjudicatory facts determine how that power should be exercised. This distinction is extremely important. If jurisdiction itself never arose, there is nothing left to adjudicate. In Carona Ltd, 2007, the Supreme Court explained that jurisdictional facts must exist before authority can validly exercise statutory power. If they do not exist, every consequential action becomes liable to be quashed. The court also explained that high courts exercising judicial review can independently verify whether jurisdictional facts existed. Now let us apply these principles to customs. Suppose customs invokes Section 28 of the Customs Act, 1962, alleging suppression, willful misstatement, or collusion. Are these merely allegations, or are they jurisdictional facts? Think carefully. Without these ingredients, the extended limitation cannot even be invoked. Therefore, their existence is not merely evidentiary. They are foundational facts giving jurisdiction to invoke the extended period. Exactly the identical principle applies under GST. Assume the department invokes Section 74 of the CGST Act, 2017. Can Section 74 be invoked merely because tax has not been paid? The definite answer is no. Section 74 requires much more. Fraud, suppression, willful misstatement, intent to evade tax. Unless these foundational facts objectively exist, jurisdiction under Section 74 itself becomes questionable. The authority cannot manufacture jurisdiction merely by reproducing statutory language in a show cause notice. Most taxpayers immediately start defending the tax demand. That is often a mistake. The first question should always be, did the department possess jurisdiction? Because if jurisdiction never existed, every subsequent proceeding becomes legally vulnerable. No amount of evidence collected later can create jurisdiction retrospectively. Jurisdiction comes first. Evidence comes later. Let us now conclude this engrossing topic. Every legal proceeding begins with jurisdiction. Jurisdiction begins with jurisdictional facts. Without jurisdictional facts, there is no jurisdiction. Without jurisdiction, there is no lawful exercise of statutory power. That is why the Supreme Court in Raza Textiles, Arun, Kumar, and Carona continues to guide every court dealing with administrative law. Whether the issue concerns customs, GST, central excise, service tax, income tax, or any other regulatory statute, the principle remains unchanged. The foundation must exist before the structure can stand. Remember this principle: jurisdiction comes first. Adjudication comes next. If you found this legal analysis useful, please like this video, subscribe to the channel, press the bell icon, and visit www.customsgst.com for more in-depth discussions on GST customs and indirect tax litigation. Thank you for watching.